generation who I knew in high school and GBSS.
Oh, you were the GBSS?
Yeah, high school.
I'm reaching my dreams with GUT. They're the ones for me. I'm reaching my dreams with GUT. They're the ones for me. Since 1983, they've been serving the country, and we like all their finance and giving the people.
Your interaction. We want you to participate. So we have two questions for you, those of you viewing on Facebook and YouTube. The questions are, by what age do you believe someone should have a will? And the second question, what is the main reason you do not have a will or living trust? Now go to www.menti.com and use the code 3902463. That's www.menti.com, menti.com, and use the code 3902463. And at the end, we would discuss your answers with the attorney at law. So, sometimes, you know, I've watched many sitcoms where someone would say, I'm going to a lawyer, I'm going to prepare a will, and the person is like, did you go to the doctor? What?
So, yeah, what's happening? You're about to dead?
Yeah.
Not to die, you know, but you got dead just now?
Yeah. Well, for us,
well, yeah, there is this, what we say maybe superstition. I don't think it's so much superstition that people don't know much about it. It's that they just don't know. It's like you see all these educational programs like now, and so on, but they really don't know much about it. But it's a very advisable thing, you know, to do. But even before I move on, Sarana, I just want to make this point in terms of a definition. I will speak about property, you know, and property is kind of generic, meaning general for both real and personal property. So we need to make that distinction, because sometimes I like to always speak about property, but then real and personal. So your personal property is really things like your gold chain, your car, furniture in your house, things like that. You know, but the real property is land, right? And anything that attaches to land. So if you have a piece of land, yeah, and you put on a concrete house on that, or you put on a house and then you start putting concrete pole and so on, it attaches. Now you make a distinction, that is real property, right? So the house is not, it's become separate, the house is part of the property. But if you had a piece of land and you rent somebody to put on a wooden house, you call it a chattel house, that doesn't become part of the land.
Okay,
So that's
okay.
not, no, you know, because anytime you give them thing, that they take up the house and run with it. So I just wanted to make that point there. Okay, so as an individual, you reach the age of 18, you know, that's the age of majority when you could vote and so on, and you're entitled to vote, and there are certain things you could do. And one of the things you can do is to make a will, right? But when you're alive, there are two things you can do if you have property, and even if you don't have property, because you never know, right? Is that you either make a will or you don't make a will. But a will is really the intention of someone, right? It only takes effect on death. I should make that point. Only when you die, right? Yeah, it doesn't take. So whatever you put in a will, going forward to just come back a little bit, can be done away with in your lifetime.
Okay.
So I'm going to make that point a little bit more. But the point is, so a will is a document, right? It's a statement or intention by people of what they want to happen with their property when they die or after death.
Okay, you talk about property. Is the term interchangeable with estate? Or
Yes, in a way. Estate is broad, you see, because the estate will include yeah, interchangeable, but I just, you know what I mean? Yeah, your estate, because your estate, yeah, when you speak about your estate, you speak of everything the person has.
Okay.
Yeah.
Okay.
And that, of course, will include real and personal property, your assets, you know, money too, you know.
So that's estate.
Yeah, everything the estate. So estate planning. So you have, even if you have one piece of land or you have 10 pieces of land, it's always advisable to settle these matters as best as you can while you're alive, and not just while you're alive, while you're in good health. Because if you could get say like a stroke, a real bad stroke, and you become incapacitated, you can't think, you can't read, you can't do anything, you can't write, and so therefore you're in a situation where you didn't even, this term will come up a little later, you didn't even give somebody a power of attorney to act for you, right? So therefore, what happened to your thing now, and you didn't make a will, you say you die intestate. So if you make a will, you say you die testate, T-E-S-T-A-T-E. And if you didn't make a will and you die, they say you die intestate, right? And there are legislation.
So testate and intestate.
Intestate.
Okay,
so there are legislations, there are laws to govern them. You have the Wills Act, and you have the Intestate Estates Act, right? Now, but we don't want to talk too much of the law in that sense, because that might confuse people more.
Okay.
But just making a point. But what the will, when you make a will, you say specifically, I leave £100 for Sarana, you know, I leave this for Camille, I leave this for Annie.
That £100 would go far.
Right, you understand? I leave this. And then when they come to land, they start saying my piece of land in La Source or Ressource or in La Digue, I give to my 3 children in equal shares. Or something else. Sometimes some of them go on to say, I give John the piece of the Dandokaya tree to the Bukuno tree, come back to the pipe stand, and it makes it very clear. And we usually encourage people when to be specific. Yeah.
Because it can be contested and cause
yeah, well, what's happening? Here what's going on. When it's what we call undivided property, so this table, and you say this piece of land I give to my 3 children in equal shares. You didn't say which part each one will get.
And what is equal?
And what is equal, because after, it depends on how the land is set out, you might have to put a road, so everybody will have access to it. So you find out that if those who are beneficially entitled, the people who are entitled to this under the will, are not cooperating, there could be a lot of fight in terms of, I don't want this piece here, you don't want this piece here, and then a lot of things could get stalemate. Nobody wants to sign the other deeds because it's undivided property, and then matter had to go to the court to be resolved. In other words, the court tend to be there to resolve matters like that, at the final thing, the court will say, well, you will get here, you will get here, and you will get here.
But for example, like what comes to mind,
Yeah.
I know, for example, family.
Right,
This man has 5 different women.
right,
He has children with the 5 of them. He marries one with whom he does not have any children,
right.
and he dies without a will.
Without a will.
What happens?
So he dies intestate. According to the Intestate Estate Act, the law governs people who don't make will, is that this wife is, well, I'm going to qualify that down the road, but this wife now is entitled to 50% of his estate,
Ah.
right? And the children, so here the qualification, who are supposed to be his children if there's documentary proof that they are his children. That is that his name
Is on,
is on their birth certificate.
Yeah.
Or they can prove in their court through the paternity, right, that I am a child of this deceased, then they're entitled to. So the 50% to the wife and the remaining 50% in equal shares to the children. Now that does be a lot of bacchanal, right? Again, if people are not cooperating. Because I like to say sometimes they never did anything for Papa. They didn't even used to come and look at him. They didn't used to check him out, right? And then when he dead, it's like somebody starts saying that. Somebody starts saying, he made a will. I know he made a will.
So you talk about will. What is the difference between a will and a deed of gift?
All right, so great. So this is one of the things someone can do when they're alive, right? When they're alive, right? Is that you avoid a lot of confusion after you die if in your lifetime you give someone a deed of gift. A deed of gift is really another deed, a title to property. So you have a property and you decide while you're alive you're going to cut it up and you give whoever you want a portion of this property.
So
it's a gift. You take care of business. Nobody can touch that. And here a piece of drama here. You can make a will and say, I have this property and I give this piece to that person, that, and you could sell one of those pieces in your lifetime and never change the will. So after you die, it's still there, but it's already gone. You see, because it takes precedent in the sense that it was done in your lifetime, right? So sometimes that creates confusion. Somebody say, well, Daddy will say that was for me. And that's what they, and then you come up and the executor say, well, look, this was sold. And then it's, you know what I'm saying? So this is the point. We're going back to the point that the will protects you, or protects those who are entitled to benefit under the estate. But at the same time, I don't want to use as a big word, and at the same time, it's just an intention. You can change it any day, anyway. And you know, amending a will is a document you call a codicil to the will. Or sometimes people squash their whole will. Probably at this point, I may want to interject something here, Serrana. A lot of people, especially married people, are not aware of this. And even lawyers, when you start to practice, you know, you learn the law, they learn the procedure a lot as you go on, because in law school, is that if you married, right, and before you married, you had a will, right? The Wills Act says, as the law governing wills, that the minute you married, that will that you made before there, later for that. Yep.
Okay.
So, so you see it, eh? So, but a lot of people don't know that. So sometimes now a guy marry a woman, and well, I'm using guys, you know, because we are the worthless ones, right?
He said it.
A guy marry a lady, right? He had this lady before. He was married before. So even if you were married before, right, and you had a will then, okay, and then you marry after, and you think, well, you see this lady I'm married to, I ain't too sure, I want to make sure my property is safe, I really want you to touch it, and you think that will still existing, that will done. You understand? So then you're making no will now because you're saying that you already have a will. But then you marry after you had made that will, so it revokes it. A subsequent marriage revokes a previous will.
Okay, so if you, so it's revoked.
It's
and
revoked.
You die.
And you die. You die intestate.
So whatever happens, happens.
So that woman now that you with gets half.
she gets it.
And if she has children, the half
Okay.
goes to the others in equal shares. You see, there's a lot of thing going on there.
Yeah. As a lawyer, are you usually the executor of the will?
No, not necessarily. But sometimes clients come and they want you to be executor. You might know them, and you might
Okay.
agree. But you often, so when somebody comes and you advise them, like property thing, you say, look, boy, you better make a will because this thing look like confusion. So you tell them, well, some of the requirements of a will is that you need to have an executor, right? Right? You need to say what property you have, both money in bank. You don't normally talk about insurance because normally when you set up an insurance, you have a beneficiary there one time. So that is not, so that's it. But money in bank, your property, your gold ring, sometimes your chain, your car, your sheep, your goat, and you say, and you want to say, all right, so these are all my properties, and then you start saying, I give or I devise this piece to John, right? I give this, that, and then you go down to your money, my money. After all funeral and expenses are taken care of, the remainder of the money in the bank or the credit union goes to 10% to this one, that, and then in all wills, lawyers ought to put in what you call a residuary clause. The residue. That is that many people sometimes own property and are entitled to property and they don't know or own property. Somebody might make a will and leave something for you elsewhere. Right?
Where?
Yeah, you understand? and what's happening is that you don't know about it. So this residuary something that I devise and bequeath all, the residue of my estate wherever and whatsoever to, etc., to the people. That's the last paragraph in a will, more or less, yeah.
Have you ever had a case where someone brought in, for example, their father or their mother, who would not be in a mental state of mind, would not be the best,
Right.
but is taking advantage of that parent to change the will for their own benefit? Have you had any cases like that?
No, not, well, nobody could come before me with something like that because that's a lot of fraud and so on. But I know, right? I've seen situations, I've seen wills where people tamper with wills. That's the thing about, so people try that. That's a very, that is really very illegal. They could get into a lot of trouble for that. And it was undue influence, right? Somebody's now well, right? And because the will requires this, and some people try that. The will says, all right, so you must have an executor. They ought to, or you should have an executor, because even if you don't have an executor, it doesn't mean that the will won't be good. But we don't want to go in that. That's law school stuff, right? But it's like the will requires that when you sign in the will, it must be witnessed by two people.
Yes.
Right? Okay. It doesn't mean that it has to be done in a lawyer's office. Because I remember the late Ovid Gill, who was one of the best conveyancers and you'll find a lawyer in this country, often say a will could be made on a piece of fig leaf. Not true. The paper don't have to be special. So you see this paper I have in front of me, although you're writing in the back, and right now you're feeling sick and you think you're going to die, and you say, I think I need to make a will. And I just make your will for you, and you sign, and two other guys here just witness it, and it's a good document.
Okay.
So it doesn't have to be done in a lawyer's office. So I'm just zeroing in on your point. So people sometimes have these homemade wills, right? Where the mommy or the daddy or auntie, somebody is not too well, not in a good frame of mind, get two other friends to come, hold on to the man or the woman hand, do a signature, and then. So now when daughter or so on come from America or England and so on, and they start saying, that is not daddy's signature. But hear the drama there, because to prove it's not his signature in court, you need expert evidence. And that is not inexpensive. You have to start with handwriting expert and other people that, so it's not.
Tampering.
So people do those type of things and so on. So it's not right. So.
It's not right, but it
Unconscionable,
happens.
but it does, yeah.
So you started talking about power of attorney.
Right.
What are the functions of a power of attorney?
Well, it's a good stopgap measure, right? When people are not in the best of health, but they still have a mental capacity, and probably they could still write, sign the name, or if someone is overseas in particular,
Okay.
and have things to be done here. So this document is a deed, is a form of a deed. So what it does, the person who gives the power is known as a principal. So like you and I, I'm the principal and you are the agent.
Okay.
And this document sets out specifically what they want you to do for them.
Okay. So you know what? Hold that thought on power of attorney.
Yeah.
We'll be right back here on a closer look. We're taking a break.
I'm reaching my dreams with GOT. They're the ones for me. I'm reaching my dreams with GOT. They're the ones for me. Since 1983, they've been serving the country, and we like all their financing, giving the people what they want, what they need, what they love. Come and join the family that's here for you all the way. From birth to graduation, your first job to your home, and your card through your golden years.
The GT Credit Union has been actively supporting nation building through its many sponsorships and programs including Financial Literacy Quiz, Pass the Torch Calypso Program, Junior Cooperatives in Secondary Schools, CPEA, and the TAMCC Grants. The credit union has helped many people make their dreams come true. Let them help you with yours. You don't have to be a teacher to be a member. So what are you waiting for?
GUT Credit Union, it's where you belong. I'm reaching my dreams with GOT. They're the ones for me. I'm reaching my dreams with GOT. They're the ones for me. Since 1983, they've been serving the country, and we like all their financing, giving the people what they want, what they need, what they love.
Welcome back to A Closer Look. I'm Sarana Mitchell, and today with me is attorney at law Ferron Lowe. We're talking about wills and deeds and the need for us to actually make wills while we're alive to protect our estate or properties. As Mr. Lowe explained, property is narrowing it down, estate is everything. And many of us are not fortunate to have estates. Now, before we went to as we're back, we want to remind you, those of you who are on Facebook and YouTube, we have a poll out there for you to answer questions. And the questions are: by what age do you believe someone should have a will? And 2, what is the main reason why you do not have a will or a living trust? Okay, so you go to www.menti.com and use the code 39 3902463. That's 3902463, and it's www.menti.com. So we're back to Attorney Law, Mr. Farron Lowe, talking about power of attorney.
Yeah, so I would say is another form of a deed. Deed is a very generic word, a broad word to cover mortgages, deed of gifts, deed pool where you change your names, power of attorney, and so on. So power of attorney is one of those. So one person gives the other power to act on their behalf. You understand? And so that power will say specifically sometimes, well, my experience tells me now that you should be as specific as possible in this power, because I noticed something with the financial institutions. If you don't say in that power, my account at GUT, right, credit union, right, specifically, and that person goes to the credit union with that power of attorney to withdraw money on behalf of that person, they usually have some problems still. So we like to be specific, right? My account at this place, my account at that place, my land here, to pay my taxes, to sign. So in that power, you see, to sign all instruments, etc., etc. So you do all that on behalf of the person, but there's a revocation clause. In other words, one of the last paragraph in the will is that that person could revoke the power.
Okay. Oh, okay.
Yeah.
Okay.
So then they give this for a specific time too. So you know, so you
that's a
could give
question.
you could give somebody a power to apply for administration or to apply for probate on your behalf. Yeah.
Okay.
You know what I'm saying? So they apply, and then the power could be broader than to give them to move on to do other things after the administration. Administration here meaning, well, administration is too is a general word when you speak of administration estate, whether the person made a will or don't made a will, you're talking about administering the estate, right? But when I speak about administration here, sometimes I speak about when somebody died without making a will. You die intestate. You apply for letters of administration in that person's estate. Whereas if the person made a will, you apply for a grant of probate.
Okay.
You probate the will, you administer the estate. Well,
So do we have in Grenada medical durable power of attorney?
you know, that's an American thing.
Okay. So we don't.
Yeah, sorry for putting it so blank and so. I see these things come from the States, durable power of attorney. And anytime I get them, I either call one of the senior lawyers, right, or I go to the registrar. Because you see, if a power is done in another country, a Commonwealth country, right?
Okay.
You know the Commonwealth,
British.
right? British, all those, Pakistan, India, some countries, in Africa, the Caribbean. Then if a power of attorney is done there and you want to have it effective here, it must be re-recorded here. Right? You can't just use it like that. You get it? So hence the reason that when we have people overseas,
Like America and so on.
England or anyway, if they want somebody here to become the agent, if they want to do a power attorney, we like to prepare it here, send it for them to execute overseas, and send it back to us. Instead of them making it out there and have it done there, and then when it comes here, we still have to do the process of registering it here, or recording it here, I should say, because we don't really have a system of registration, before it can be active, before you can start using it.
Okay.
So you can give somebody a power to do anything.
Okay. So the same. So
But when the person, if the person dies, the power dies with them.
So if for example, is there a term under the British law system that Grenada follows for if I'm sick and for that period of time I want to give power of attorney to someone?
Yeah.
Is there a term for that, or is it just still power of attorney?
No, it's no special term. As I say, you're just mentally capable. You understand? So this is critical. You know, if somebody is sick and not, you see, hence the reason that anytime I'm doing a power, right? But if not for if somebody is up and about, or if I'm sending it overseas for the person to sign and send back to me, I often either get the magistrate in the district, because they act as registrar, you know, in the district, or I get a registrar to go with me to the person's house. They will ask certain questions. Ma'am, are you aware of what's going on? Do you know? And they read it, and you know, and everything, and then sign. Some of them make an X because they can't really sign the name, and that is considered a proper signature if it's done before the magistrate or the registrar or a judge, and so on. That's important.
Okay, so for example, if for example I'm married,
Right.
not, but anyway,
Right.
so my husband, my make-believe husband is from, say, Trinidad,
Right.
and he's in business with his mother, and he marries me. She has power of attorney over the business.
Right.
Does that trump me if he dies?
All
She
right.
makes the decisions, and I'm just
All
like,
right.
nothing.
So your husband has business with your mother,
with his mother.
with his mother. She gives him a power.
She has power over the power attorney over the business.
Oh, so he gives her a power attorney
Yes.
over the business.
Yes.
And then he dies.
Yeah, he dies.
He dies. Power dies. So
So-
you come back into the picture, big
Ooh.
time.
Yeah.
Yeah. Yeah. Especially if he doesn't make a will, right?
Sorry, I don't mean for you to die out.
If he comes back into the picture, if he didn't make a will, you come back in the picture. If he makes a will, you may not be in the picture. It depends. But by the way, the law is now that if a husband or a wife, we should bring in you all too because you have your thing going.
Yeah.
Makes a will and did not provide anything in the will for the spouse, the law provides that you could challenge. You could go to the court and say that, he has not left anything for me there and I made contribution and I am entitled to. I just put it in as low and easy language as possible.
But-
You could challenge it. A spouse could go to the court and say that he, that will didn't provide anything for her, and she's really entitled. And
But
the law-
doesn't she already get 50%?
No, that's if he made a will. I'm talking
Oh,
about.
okay.
If he doesn't make a will,
he
it's a
doesn't
different
make a will.
story. Yeah.
Okay.
So in other words, you see how the law is moving because again, you said earlier, I say men worthless, right? But why you think that came in? Because most of the time this is what been happening. The world was very sexist, and men took advantage of people generally, right? And they took a lot of advantage of women. I mean, they deny women the vote over the years. They deny women a number of things throughout the generations, right? And if you don't come up and have these protections, it's just like how child labor, they had to ban all these things because
Yes,
in some
yes,
cases
yes.
it still
And
exists.
we're
in
still
some
fighting
countries.
for certain
We're still
things.
fighting, yes.
Yes.
So it's like catch up then, in a way, right?
No mustard.
Yeah.
But
Yeah.
so let's see. There is a lot of talk about first child and last child
Right.
powers. Like, the father gives everything to the first child.
Yeah.
Or I've heard talk about the last child. Please explain.
I think both concepts, if you want to say the first and last child, there's a lot of, I don't know where it came from. The first child thing came from the Bible a little bit, right? I mean, and I'm not being blasphemous or anything like that. I'm just saying that in terms of the air, and that kind of stuff. And you see, like the British, it was monarchy and the nonsense, like first the heir to the throne, right? We could afford to chant them down, especially coming out of all the Black Lives thing and the education we've been getting about how we
And
were
Barbados.
exploited over the years.
And Barbados making the
And so
decision.
Hillary Beckles been giving us a lot of that history of what's really happening. So you could say that they exploited us badly. But anyhow, so we can go in with that, the heir to the throne, right? The point is that the first child thing is really not something in law
Okay.
as such. You understand?
Thank you very much.
But so some people, and it's common in Grenada, not very common, it's 2-3 generations ago, would always think that they believe that the first child is honest too. So they put everything in the first child care. I've seen these like that. People with a lot of land and they give it to the first child, and that first child in England and so on and so forth. And there's a mentality of some of them when they go overseas and they come back, they feel all of us is stupid. Right? So they come back and they're giving these other siblings real trouble to really distribute what their father had intended him to do or her to do. And so that first child thing, we had to knock it out the way and really apply the law as possible. So I
And
would
create
advise
wills.
people, don't put all the property in one child's name with the intention that that child would distribute to the other children. That's
trouble.
dangerous, that's trouble.
trouble.
That's why the will is important.
Yes, the will.
And if you don't
be
make
very
a will,
clear.
yeah.
Very,
So
very
so you
clear
see,
cut.
but I say I've seen deed where they just convey. So it's a deed of gift in their lifetime. That we come back to the deed of gift. They give a gift of the property to James or Annie, first child. But most of the time it's a boy. I think they always trust the boys. I don't know why. Right? But most of the times the male gets this first, and then it creates. I've seen it. It's such a bad procedure. It's such a bad way to go about things, and it creates problems. Because generally, look, I mean, let's face it. You know, before people made a lot of children, 15, 10, 9, you know, a lot of children. You wonder how they used to do this thing, you know.
I had a great hand at 20, but anyway.
Yeah, a lot of children. I mean, in my village in California, I grew up, I knew people at 15. I think the lady had 19. When she reached on the 19th, the child came out just like a protoplasm. Yeah, if those people doing biology would know what I'm talking about. You know, it wasn't that. She was just, and some people, you call them real breeders, right? I mean, we're not going off the target, but no, I'm just saying it's not.
I had
it's
a
like,
vision when you talk about
it's like, it was a level of sexploitation and exploitation.
Yeah,
You
that's
just
all they
make
did.
children, right?
Yeah.
And sometimes, and I'm talking about sometimes the nuclear family, you know, right? But the point I'm making is that when you have all these children, right? What do you think gonna happen? All of them won't be pulling with each other.
Yeah, and
You understand? And then you leave property just hanging out there. So these days, now we have the very smaller families, right? With 3 and 4 and 5 children, and we still see the problem. Because that's just how some siblings always have to have a quarrel.
Not just siblings, just people in general.
Yeah, and over property.
Yes.
And you know what I usually tell them if I call a meeting, because you know I stay away from litigation. I don't like the court.
So you're a mediator.
I think that a lot of issues that go to court can be settled in the law office if the lawyer begins stand up and put some sense in some of the client's head. Let's put it in that kind of way. In other words,
To your counselor.
yeah. In other words, I usually say to them, "Watch, you're going to spend $10,000 to go in that court, but a lot of them want to, they want their rights, they want to get the day in court." I say, okay, the same thing I tell you here, the same thing the judge going to eventually tell you in the end,
And
you spend all this money. I don't care. I want to go to court. Well, you go right ahead. You understand? But several times the thing could be resolved. But you know what I usually tell them? I say, in the finals, I say, "Did you buy that? So why you feel you're entitled to it? You understand the way you're getting on? Your parents paid for it. They work hard and buy it, and now you come in fighting saying this piece had to be mine and that piece. Go and get your own."
Exactly.
Yeah, really,
So,
actually.
God bless the child has his own. Anyway, but for example, yeah, what about the last child talk?
The last child talk is a lot of nothing, right? Yeah, you know, we
good.
can't say that on air, right? Yes. So it's a lot of, yeah, that can't run. That, again, is your wish. If you want to do it, you do it. But there's nothing in law saying that that's how it ought to be.
And we go back to the need for the
Will,
and
yeah,
being
yeah.
specific.
And leader gifts. You
Yes.
know, I have this thing. I usually advise some of my clients, I say, "Watch, hear what?" Yeah, and I'm glad we brought this thing because I want to talk about life interest too. Life interest. And sometimes you see it in wills. Somebody has a property. They said, so a man makes a will and he says, "I give my property in La Digue to my wife for her life. And after she dies, to my child or to this person or that puppy." So they create a life interest there. Okay? No, that is in a will. You can do a similar thing in a deed. So you have property because you know them children might be rascal a little bit and might take your property and sell it while you're alive there, and you know you in the house and sell it, and next thing somebody come and put you out, right? So the child might want to go to university, might want to study, and they would need some level of security. But you still not trusting to give everything. So what you do, you create, you do a deed of gift. You give yourself so it's your property, your name on the deed, but you do a new deed and you give yourself a life interest, and so it's like you to yourself as a life tenant, we call it, and then two. So say you
protect yourself.
So you protect yourself. So you still hold the property. You still have an interest with it. So the child can't do anything without you, and you can't do anything without her because you brought her in the scenes. Yeah. Wow. Because you see, it does happen. People take their parents sometimes want to give you something to help you get a loan from the bank or the credit union and so on, right? But sometimes the child have different headspace. Yeah. The minute they're gone overseas, they forget mommy and everything, and the land gone. There are nobody else. Or sometimes, but so the life interest, you could always have a life interest in your property too, even if you own it. But I still advise. So that's one thing I would advise, that if you still want to be certain, you want to stay in your house still until you die, you keep your name on this new deed, but you give, so that could be a life interest. But also you could go as joint tenants or tenants in common. Yeah, I should bring that in. That's something
when we come back, you're going to explain about joint tenants and tenants in common.
Yeah.
You are watching A Closer Look. Please go to menti.com. That's www.menti.com, and answer the questions to our poll on. If you're viewing on Facebook or YouTube, the questions are: by what age do you believe someone should have a will? And what is your main reason why you do not have a will or living trust? I'm Sarana Mitchell. We'll be right back.
Reaching my dreams with GOT. They're the ones for me. I'm reaching my dreams with GOT. They're the ones for me. Since 1983, they've been serving the country, and we like all their financing, giving the people what they want, what they need, what they love. Come and join the family that's here for you all the way. From birth to graduation, your first job to your home, and your card through your golden years.
The GT Credit Union has been actively supporting nation building through its many sponsorships and programs, including Financial Literacy Quiz, Pass the Torch Calypso program.
Welcome back to A Closer Look. And with me here today is Mr. Ferran Lowe, attorney at law at Siboney Chambers. I'm Sarana Mitchell, and we're talking about the need for wills. To make your wills and deeds of gift and be very specific, because we want to eliminate drama, too much drama. And before we went to break, we were talking about joint tenants and life interests.
Right. So I'd introduced the concept of life interest, right?
Yeah.
So I was saying in a deed you can have a life interest, and then the thing would say and remainder too. Right? The person so more than one person own it. Now the other scenario is that it doesn't have to be a life interest. You can hold it jointly, right? Jointly in the sense that you have two phrases there as joint tenants, right? So you and I, right? So the property was mine, then I bring it in, so now you and I own this property together with a new deed, right? But at the end of the deed, right, the conveyancing clause, you have to be clear what you're saying there. To hold the same unto the use of, right, the grantees, right, or whoever it is, as joint tenants or tenants in common, and sometimes you're going to say in equal shares. So anytime we talk about tenants in common people. So the joint tenants is this. This principle works like this. That if you hold property as joint tenants, if you see a deed like that, to Ferron and Sarana as joint tenants, it means if one of us died, the property automatically goes to the other one, as we say, without the stroke of a pen.
Ah, okay.
By operation of law, we says, right? So
if you don't want that to happen,
if you don't want that to happen, you go then to tenancy in common. You hold it as to Ferron and Sarana as tenants in common. You might say in equal shares because you all own it equally, or you might say in the following shares. Maybe I have 2/3 and you just have 1/3. Right. It means then that if either one of us die, my share in that property remains in my estate. You get it? So when my estate is administered, is that share that's being, your share still remains as yours.
So good. So
Yeah.
what's a different terminology? So you have tenants, joint tenants, and
right.
tenants in
In
common.
common, yeah.
So tenants in commons means that
Common, not common, yeah.
means that
each person's share is separate.
stays separate. So
yeah. So in joint tenancy, the shares are just there. You own it together. You could, and even if you make a deed as joint tenants, you could also down the road sever,
ties.
cut the joint tenancy, create a.
And
Yeah,
so
you
tenants
know,
in
the law is very versatile. You know, some people say the lawyers are crooked, but we're good people. You know,
Is that so?
Yes.
I have to ask you a question. Do you have a will?
I won't answer that. But lawyers are
On American
notorious.
system, you plead the fifth.
Yeah, lawyers are notorious. It's just like you say, doctors don't go to doctor. They don't check on themselves. They check on everybody else. Lawyers don't take care of themselves too, they say. They do everybody else's business and their business in things.
So,
in chatters.
with that last statement
Yeah.
there, you're making me question. Anyhow,
Let me hear.
what should you do if you do not want your will to be contested?
Okay, if you don't want your will to be contested, well, that's kind of I wonder if you're saying is that, all right, so the will, you must make sure you do the requirements as set out in the Wills Act.
Okay.
You know, is that the will, there should be a name to the will. If you're making a will, it should be I, John Jones, of so among Morris, in the parish of St. George, right? That first paragraph often say you revoke all wills before, and this is now your last will. You normally would name an executor, but as I say, that's too much law if I start talking. But if you don't name an executor, the will is still a good will, because one of the people who are named as a beneficiary in the will could apply for
Secretary.
not apply for what you call a letters of administration with the will annexed because they were not named. But as I said, that's law. But it's still a will because everything else remains.
Okay.
But one of the persons then takes up the administration. One of the persons who's named as a beneficiary in the will becomes the administrator of that estate.
Okay.
You get it, right?
Okay.
Right. But as you're saying, to make it uncontestable, right? See, you must carry the. So a date is critical, right? The signature witnessed by two witnesses in his presence at the same time, critical, right? And no scratching up on will and rubbing off with rubber and scratching with the razor blade. Anytime you see that, later for that. That is a problem.
Razor blade?
Yeah. Oh, yeah, all kind of thing. So you don't tamper with a will. Okay. And if there can be a correction,
Signatures.
exactly, initial, but we try to avoid that as much as
It
possible.
makes it messy.
Yeah, it makes it messy. You know, this is the kind of exams question you get in law school. You know, what the will is that. But you don't tamper with a will, and people tamper with wills. Some people make over will. Yeah.
Sounds interesting.
Yeah, but those requirements, I think I get it. The name, the date, the signatures of the testator, as we call it, the person who make the will,
Yes.
and
Witnesses.
at the time, and so on and so forth. Yeah.
So some takeaways, what we must remember. We must remember.
Well, you have to remember you're only living forever, and that one way to continue to enhance love among people and to avoid confusion is to settle your business while you're alive. And that is one way of settling that is to make a will or to give people what you want to give them while you're alive. You know, either gifts or you convey the property to them, as we say, gifts and so on, and settle things. And things, that's one thing. Try and settle it. If you don't want to make a will, because I know some people who don't make will and people get along well, right? And they settle the property afterwards, because if they die intestate, father dies and he dies and the spouse already died, the property goes to the children in equal shares. So
Do you see that happening often?
You mean confusion or
No confusion.
no, yeah, they're things are not that bad, you know. But I'm just saying is that the confusion sometimes is too common.
And it's so noisy.
And it's so noisy. And it's like, rah, 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 down the road. But I think that's a fair enough takeaway. Try and settle your business while you're alive.
Okay.
Right? And by the way, so if you have young children, you see, that is something that's critical. So the trust thing comes in there. And you're making a will, you have to remember, you know, that
Who takes care of your
who
children?
takes care of them and so on, to put that in there.
Yes.
And sometimes, going back to deeds again, you could make a trust deed. You see, you could convey property to minors, people under 18, but you must have a trustee to hold that property for them.
Which, as you're talking there, what
regain
comes
the
to
age.
mind is a lot of the monarchies and them in England when the children, it passed on. They had this one looking after and this one looking after the estate, and a lot of confusion going on.
Correct.
And signing paperwork back and forth and all of that.
That's it. You know, so that's something. Yeah, I'm glad we kind of get to that point in wrapping up because you know, you have the court is very strict about the protection of children and so on, right? So when you're doing your thing, and this is why sometimes if you know you could make a deed and that child is under 18 or he's still a minor, you make a deed so it's from you, the trustee holds on behalf of that person. And when that person gets to the age of majority, they're ready to fly. Give them the thing, let it go. Yeah, it's just like when a parent dies, right? And they're still on the estate and they leave young children. When the administrator is applying for the administration, you have to have two administrators, a co-administrator. The law demands that where there are minors involved in an estate, there must be a second person joining to administer, to apply for the grant of probate. That second person is to seek the interests
Of the children. Okay, excellent.
Yeah.
Thank you. But before we leave, we're talking about the poll questions. By what age do you believe someone should have a will? According to your responses, those of you watching Facebook and YouTube, 15% said 25, by the age of 25. 69% says by the age of 45, and 15% says by the age of 65. So 25 and 65 equal, but the majority are you shouldn't have a will by age 45. What do you say, sir?
You should have a will from the time you're in law, provided you could have a will, if you're aware of it. Right? Because you see what's going on these days. It's not old people dying, all ages going through, right? And people own, unlike before, somebody 18, 20 didn't have any property. People who are 18, 20 have property now. Oh, and by the way, should we have time to say? So, if you didn't marry and you die before your parents, right? But you have property. Parents. Oh, you go see your parents.
Yeah.
Oh, you know that, right? Right. But if you have no parents and you have siblings, you go see your siblings.
Well,
yeah.
And you don't have a will.
If you don't have a will. Yeah, and you don't have a will. But as I say, back to that, the minute you're conscious of it and you're aware of it, and sometimes, And if you're in the military, and if you're a seaman and so on, you don't necessarily have to have a written will, right? Sometimes, huh? No, yeah, that's another technical thing. Your commanding officer, the captain of the ship. So if you die in war, right, that's a level of trust that the law cannot give to commanding officers and so on. And you dare, sorry for putting it so vivid, and you're about to die, you got wounded. You could tell your commanding officer what you want happen with your property. And he then back could, report says trust. Yes, say that. John said, my girlfriend back in Grenada should have my house, and so on and so forth. Even if he was not married, right? You see, but his parents are alive, he would have been entitled to it. So the same thing for seamen, the merchants, and so on. That have that kind of system.
Firemen as well? Dangerous?
No, not that. No, them on the ground here.
When they go fighting fire.
Yeah, this time. Next question.
Next question. What is the main reason you don't have a will or living trust? Don't need and don't. That's 38%. So don't need and no assets to leave.
Right.
My eyes are pretty good. 38%. Don't need one and no assets to leave one. And the next one, 19%, it's too expensive.
Yeah.
19% equal, don't know how. And 24% superstitious. So we have 38% don't need and have no assets. 19% it's too expensive. 19% again equal, don't know how, and 24% superstitious. So we have it.
Yeah, well, the first one you could just dismiss because you can understand if somebody even has no assets and so on, well, I don't have to make a will, right? So I could go along with that. But you see, number two, it's not expensive. I don't know which lawyer you go to, right? But a will is not expensive.
Okay.
Right, so I just say that. It's not thousands of dollars.
Okay.
But some people probably charge thousands of dollars. But I won't tell you how much I charge. Then don't know, I think is a credible thing.
Well, this session here is helpful. Was helpful to them.
And the superstition have a thing, about it, right?
Yeah, you make it will you go
Boy,
down.
you make it will you go dead. Yeah, so let me stay right here still, you see. So, but the middle ground is very plausible. Don't know how. Don't know. Yeah, so this program is a good
This
education.
session was very helpful.
And let me tell them, they could make it at home. Just remember the requirements. You need a name, you need a date, you need two people to sign. Yeah, but you have to say things in the will too. You can't just make a will and you have no subject matter, as we would say. There had to be something you're giving away.
If you don't have any assets, I'm giving my eraser.
Yeah. But somebody might have a thing,
I give him my pen to
something that passes down is a wedding bands from mom, and things like that. You have some cherishable things.
Oh, okay.
That's good.
I'm trying to think about what real I have.
What real?
And real property, and what was the other one?
Personal property.
Personal property.
So we had a
property.
distinction. Personal property, your personal things. Your nice car, the BM, the Beamer, and this and that.
Okay. All right. Well, thank you very much, Mr. Ferranlo. Thank you so much. And those of you viewing at home on Facebook and YouTube, thank you for joining us here for the past 5 weeks, so the many topics that we shared with you. I do hope that it was elevating. When I say elevating, it lifted you and give you information that would help you to make informed decisions that will better your lives. I want to say thank you to GUT Credit Union and the whole team here. And those of you can always go back to Facebook and YouTube and look at the recordings. Thank you so much. Have a great one.